A debt collector can be fined $1,000 per violation, per phone call, for threatening you illegally. And most Americans have no idea that law even exists. Right now, someone is sitting at their kitchen table, hands shaking, staring at their phone after a debt collector just told them they were going to be arrested if they didn't pay by end of day. That person feels completely alone. They feel cornered. And they have no idea that what just happened to them was a federal crime. That person might be you. Or someone you love. And that's exactly why you need to hear this. The Consumer Financial Protection Bureau reports that debt collection is one of the top sources of consumer complaints in the United States, year after year. Millions of Americans are contacted by debt collectors every single year, and a significant portion of those contacts involve threats, intimidation, and outright lies. The collectors are counting on one thing, that you don't know your rights. That changes right now. The law that protects you is called the Fair Debt Collection Practices Act, the FDCPA. It is a federal law, passed in 1977 and enforced by the Federal Trade Commission and the Consumer Financial Protection Bureau. It applies to third-party debt collectors, meaning collection agencies, debt buyers, and lawyers who collect debts operating anywhere in the United States. Every single state in this country falls under this law. And it is one of the most powerful consumer protection tools ever created. Here are the 3 core rules the FDCPA sets that debt collectors must follow, rules they violate constantly, often because they know most people won't push back. Rule number 1, debt collectors cannot use threats, harassment, or abuse. Under Section 806 of the FDCPA, it is illegal for a debt collector to threaten you with violence, use obscene language, make repeated calls intended to annoy you, or make false threats of legal action. Here's the part that shocks most people: a debt collector who threatens you with arrest is breaking federal law. Collectors cannot have you arrested for a civil debt. They are not law enforcement. They do not have that power. When they say otherwise, that is a federal violation. Every single time. Rule number 2, debt collectors cannot lie to you. Section 807 of the FDCPA prohibits false, deceptive, or misleading representations. That means they cannot claim to be attorneys when they are not. They cannot tell you the debt is larger than it actually is. They cannot threaten to sue you if they have no legal right or intention to do so. They cannot tell you that failing to pay will result in your wages being garnished without a court order, because that requires a judge, not just a phone call. If a collector tells you something that sounds designed to terrify you into paying, there is a strong chance they just broke the law. Rule number 3, debt collectors must give you validation rights. Under Section 809 of the FDCPA, within 5 days of first contacting you, a debt collector must send you a written notice that includes the amount of the debt, the name of the creditor, and a statement that you have 30 days to dispute the debt in writing. If you dispute the debt within that 30-day window, they must stop collection activity until they send you verification. This is critical. If you never received that notice, or if they ignored your dispute, that is another violation. These rights are not optional. They are the law. Now let's talk about what this actually looks like in real life. Consider the situation faced by a woman named Maria, a single mother in Ohio who owed around $4,200 on an old medical bill that had been sold to a collection agency. Over the course of 3 weeks, the collectors called her at work, after she had explicitly told them not to. They called family members and told them about her debt, which is a direct violation of the FDCPA's prohibition on third-party disclosure. And then one afternoon, a collector told Maria that a sheriff would be at her door within 48 hours to arrest her if she didn't make a payment immediately. Maria was terrified. But instead of paying, she did something smart. She wrote down every detail of every call, the date, the time, what was said, and the name the collector gave her. She sent a written dispute letter via certified mail, return receipt requested, within that 30-day window. She filed a complaint with the Consumer Financial Protection Bureau at consumerfinance.gov and with the Ohio Attorney General's Office under Ohio's Consumer Sales Practices Act, which mirrors and in some ways strengthens federal protections. She then contacted a consumer rights attorney. Here's something most people don't know. Under the FDCPA, if you win a lawsuit against a debt collector, they are required to pay your attorney's fees. That means many consumer rights attorneys will take these cases at no upfront cost to you. The collector pays if you win. Maria's attorney filed suit in federal court. The case was settled. She received the maximum statutory damages of $1,000 for the FDCPA violations, plus additional damages for emotional distress and the illegal third-party disclosures. The debt itself was also disputed and the amount reduced. Maria didn't pay a single dollar in legal fees. The collector paid all of them. This is not an unusual outcome. This is how the law is designed to work. So here is exactly what you need to do if a debt collector has threatened you right now, today. Step 1. Document everything immediately. Write down the date, time, the collector's name, the company name, the phone number they called from, and word for word what they said to you. If your state is a one-party consent state for recording calls, which many are, consider recording future calls. Check your state's law first before doing this. Step 2. Send a written dispute and cease communication letter via certified mail with return receipt requested. Once a collector receives a written request to stop contacting you, the FDCPA requires them to stop, with only 2 narrow exceptions. Keep a copy of everything you send. Step 3. Request debt validation in writing. Ask them to prove the debt is yours, the amount is correct, and that they have the legal right to collect it. Do this within 30 days of their first contact. Step 4. File complaints immediately. Go to consumerfinance.gov and file a complaint with the CFPB. File a complaint with the FTC at reportfraud.ftc.gov. And file a complaint with your state attorney general's office. These complaints create an official record and trigger investigations. Step 5. Contact a consumer rights attorney who specializes in FDCPA cases. Use the National Association of Consumer Advocates directory at naca.net to find one near you. Many offer free consultations and take cases on contingency, meaning you pay nothing unless you win. Step 6. Pull your credit reports. Go to annualcreditreport.com and review all 3 bureaus. Illegal collection activity often shows up as improper entries. If a collector has added inaccurate information, that may also be a violation of the Fair Credit Reporting Act, the FCRA, giving you additional legal grounds. You have rights. Federal law put them there. And the collectors threatening you are counting on you never using them. Save this video right now, because the next time you get one of those calls, you're going to need these exact steps, and you'll want them at your fingertips. Subscribe to this channel so you never get caught off guard when your rights are on the line. We break down exactly how to fight back using the laws that already exist to protect you, in plain language, every time.